Hear ye, hear ye. All manner of persons having anything to bring before the honorable justices of the Supreme Court of the state of Delaware will now draw near and give their attendance. The court is now open. God save the state and the honorable court. Please be seated.
Good morning, everyone. Thank you, Capitol Police, for being here today. All right, do we have introductions?
Yes, Your Honor. Your Honor, William Crawford on behalf of Cincinnati Insurance Company. Joining me at council table is Amanda Dobies and Jonathan O'Neill from Kimmel Carter on behalf of Mr. Henry.
Thank you very much. Mr. Baker, you may proceed.
Thank you, Mr. Chief Justice. Justices, before I begin, I'd like to introduce my colleague and co-counsel, Francis D. Nardo, Esquire. To acquaint the court with the background of this case, Mr. Henry was an employee of Horizon Services. Horizon was insured for purposes of workers' compensation by Eastern Alliance Insurance Company. When Mr. Henry was involved in a work-related accident due to the negligence of a third party, Eastern paid workers' compensation benefits in excess of $500,000. Horizon was also insured by Cincinnati Insurance Company for purposes of UIM coverage. This court has already concluded that Mr. Henry has the right to assert a claim for benefits pursuant to Horizon's UIM coverage. And he has that right because the UIM carrier is not considered to be the employer, but instead steps into the shoes of the tortfeasor. As such, this appeal presents the question of whether under 19 Delaware Code Section 2363, the employer's workers' compensation carrier has the right of reimbursement against the UIM recovery, since it now is a third party standing in the same shoes as the actual tortfeasor. As such, for legal liability purposes, the UIM carrier is a third party from whom the employee can collect whatever damages that he can collect from the tortfeasor. This holding leads us to the question presented to the court today. Because this court has held that the tortfeasor and the UIM carrier are one and the same in terms of responsibility to Mr. Henry, it is our position that by extension, the UIM carrier is a third party from whom Horizon's workers' compensation carrier should likewise be able to seek reimbursement from Mr. Henry pursuant to 19 Delaware Code Section 2363. As this court has held as recently as 2020 in ACW Court versus Maxwell, it is the second sentence of 19 Delaware Code Section 2363 which defines what the workers' compensation carrier can recover against a successful recovery by the employee against a third party. That sentence states in pertinent part that, as to any recovery against the third party for damages resulting from personal injuries or death, shall reimburse the employer or its workers' compensation carrier for any benefits paid or payable under the Workers' Compensation Act to date of recovery. I submit that to hold otherwise would result in the employer paying twice for the same loss. First, from its workers' compensation coverage, and second, from its UIM coverage.
So can you just help me with that? I know you've characterized it as paying twice, but it's not directly paying twice. It's not like it's out of their pocket. They're paying it from the proceeds of an insurance policy that they bought.
Well, yes, I recognize that, Mr. Chief Justice, but this court has always held that a double recovery is something that should be disfavored because the claimant is recovering twice for the same damages. And he is recovering twice because his employer undertook not just to buy workers' compensation coverage, but also to purchase UIM coverage. And this court has always held that when the employer funds the coverage, such as short-term disability, that there is a credit or a recovery against that so that two carriers are not paying the claimant for the same damages. And in this case, that's what would happen because Mr. Henry, by asserting his UIM claim, is essentially putting forward, in the context of that claim, the same damages for which he has already been paid $500,000 by the workers' compensation carrier. And so to prevent any right of subrogation would mean that he would recover against two sets of tortfeasors, the actual tortfeasor and the substitute tortfeasor, which this court has deemed the UIM carrier to be. And it was
Baker,
for that.
if I can just interrupt. Under your theory, would the employer be able to assert, or the workers' compensation insurer be able to assert a lien against a recovery that the employee might obtain from its own UIM policy?
Absolutely not, and I think that's an important distinction, Justice Legreau.
Can you tell me where textually within the statutes you find that distinction?
Well, I think the distinction is set forth by this court's decision. This court decided the case of, let me just find the citation, Adams versus Delmarva Power. And in that case, the employee had purchased the coverage, and as with any benefit that an employee purchases, in this case for herself, the purchaser is entitled to the benefit of that purchase. But in this case, we're talking about a benefit provided by the employer. And the court has always treated that differently because the employee made no contribution to it, and it was solely funded by the employer. That has also been the case for, as I mentioned a moment ago, short-term disability. If the employer purchases short-term disability, then it's entitled to an offset. If the employee purchases short-term disability, then it is not. And that's rightfully so, because it's the property of the person who purchased it.
Mr. Baker, if I can follow up on that. I think the question was where implies a search for the textual basis for that distinction. Is it your position that Adams essentially announced a policy judgment as to that supported drawing a distinction between employee purchase UIM coverage and employer purchase UIM coverage?
Sure. If we go to the text of 2363, it does not talk about who purchased the policy. It simply states that in an action to enforce the liability of a third party, that the recovery against that third party for damages resulting from personal injury or death is payable back to the workers' compensation carrier. So the statute itself is silent with regard to that distinction. And this court has interpreted the statute in such a way that it has drawn a division between policies purchased by the employer and those purchased by the employee.
If I could ask another question, apologies for interrupting your flow, but a good bit of your brief deals with the 2016 amendment to Section 2304. Your argument today focuses on 2363. Do we really have to deal with isn't the answer to the question before this court in our interpretation of 2363E?
I believe it likely is, Your Honor, because that's what the thrust of the argument by my friends on the other side and also by the lower court amounts to. And I think that is an important thing to focus on, because the lower court and the appellees both focus on what I deem to be an exception to the right of recovery as opposed to the rule. If you look at the language that the appellees cite in their brief, it specifically references the following. Reimbursement shall be had only from the third-party liability insurer, and shall be limited to the maximum amount of the third-party liability insurance coverage. However, that follows these words, except that for items of expense which are precluded from being introduced into evidence at trial by 2118 of Title 21, reimbursement shall only be had.
That's the PIP, right?
That is PIP. So what that statute says is that evidence of damages that are payable by PIP, because the claimant or the plaintiff cannot prove them at trial, he's statutorily precluded from bringing them forward as evidence at trial, then we have to go against the liability carrier for those specific damages. But that is an exception to the general rule, which is that any recovery against the third party for damages is recoverable in subrogation. And so I think that what happened is that the lower court overread that exception and treated it as though it were the rule.
Well, that also was the approach that Simmendinger Court took. And what would you have us do with Simmendinger in this case?
Simmendinger was a derivative action that took a step forward, if you will, from the Hearst decision, Hearst versus Nationwide, in which in a footnote, the court stated that the General Assembly had eliminated the ability of the employee's workers' compensation carrier to assert a priority lien against the employee's right of reimbursement, the employer's right of reimbursement. But the court did not elaborate how the legislature had done so. And as I stated, the only amendment that was made to the statute was the one that I cited to you earlier, which is the exclusion, which is that except for, as the Chief Justice stated, PIP eligible benefits, the right of recovery is absolute. And if the right of recovery were always limited to just the liability coverage, there would be neither reason nor need for the legislature to single out PIP eligible benefits as those which must be asserted against the liability carrier. So I think that that is where the intersection was made in terms of overreading the exception and turning it into the rule.
So are you asking us to overturn Simmendinger?
I'm asking you to do so and revert back to the policy which you had in place before, which was Harris versus Newcastle County, because this court specifically stated in Simmendinger that it was not overruling Harris versus Newcastle County, which did acknowledge that right. As the court stated specifically in Harris, the court said, decisional law finding a statutory lien or right of subrogation not to extend to uninsured motorist coverage is in large part premised not upon reasoning or statutory construction with which we agree. So therefore, you were recognizing at that time a statutory right of reimbursement from the UIM carrier. It was only in response to the amendment, which I submit had nothing to do with UIM coverage, that there was a departure from that rationale.
Why can't we just decide this case on the basis of the exclusion in the UIM policy against double recovery?
Well, I think that that's a place to be decided in another forum. There is an action that Mr. Henry has brought in which the contract is at issue. Here, we are simply asking the court to address the right of recovery from a legal standpoint, as Justice Traynor mentioned, under Section 2363.
So I get that, and I have to say, I don't understand your argument in response to their argument about the exclusion.
Well, I submit to Your Honor that really is an issue between Cincinnati and Mr. Henry, because the reason I say that is because we're not here to decide whether Mr. Henry has a right to recover from Cincinnati or not. We're simply saying that if he does, we have the right for reimbursement from that. So I think that that's the separate issue that needs to be addressed in a different forum, and that will determine whether or not we have a right of reimbursement. If the exclusion applies, and it applies to Mr. Henry, and our rights are derivative of his, not direct. So if he has no right of reimbursement, then we have no right of reimbursement. But if he does, and the court will determine that in due course, then we have a derivative right of reimbursement from him because of the statute, which says that we have that absolute right except in the narrow circumstance of cases for PIP eligible benefits.
Mr. Baker, can I just clarify your argument with respect to 2304 and partially your response to Justice Traynor's earlier question to you? Is it your contention that the version of 2304 that existed before the 2016 amendment bars the lien, or are you saying something else?
Well, this court essentially held, Justice LeGros, that it makes no difference. The argument was posited in Henry 1, the decision that you already rendered, that whether or not the statute was amended, the UIM carrier was always a third party and not the employer. So by extension, we're not talking about whether there's an exclusion because it was purchased by the employer or the employee. This court has said it's neither one. We're treating them as the tortfeasor. So therefore, for that reason, the court didn't need to reach the issue of whether the amendment made any difference to Mr. Henry. But in this case, since it now doesn't specifically include UIM, that would be just an added reason or an added layer of information showing why we would be entitled to reimbursement, because he now specifically by statute, as well as by this court's ruling, is entitled to reimbursement of UIM benefits because the UIM carrier is the tortfeasor. And since they're a tortfeasor, they're a third party. And since they're a third party, we have the right to subrogate against them, since the benefits that we are seeking are not falling under the exclusion or the exception created by the amendment to the statute. only applicable to PIP eligible benefits.
Mr. Baker?
Yes, sir.
Henry, you mentioned Henry 1, we'll call it, and
Yes.
then Robinson, they make clear that the Workers' Compensation Act is not retroactive. How do you maintain that this latest version of the exclusivity provision is not in play?
Well, Henry 1 ruled that, Justice Griffiths. They held that it is not a matter of retroactive or prospective. It doesn't apply by its own terms because the UIM carrier is not the employer, but a tortfeasor. So therefore, we don't need to reach that issue because this court has already extended to Mr. Henry the right to pursue UIM benefits. If he has that right, the question that follows then is, do we have the right to subrogate against those benefits? So to hold that it applies to us but not to him would create an artificial distinction because we would not have the right while he has the right based on the same provision. As Justice Traynor indicated, I think this case rises and falls on 2363 because it gives a universal right of recovery except in very narrow circumstances which are not applicable here. Since the court did not overrule Harris, but distinguished it based on the amendment, I submit to you that the amendment is very narrow, that it is very limited, and that it is not applicable to the broad brush with which the appellee and the lower court wish to paint. Again, I would urge you to carefully read that the statement in 2363E states except that for damages of items of expense which are precluded from being introduced at trial by 2118 of Title 21 PIP, reimbursement shall be had only from the third-party liability insurer.
Is the source of all this that footnote in Hearst? And if so, how does one come to terms, and I'll ask your friends the same question, with that footnote, how does the amendment do what the footnote implies that it did?
I submit, Justice Traynor, that it did not. The court certainly doesn't give any indication for it. The footnote, as I'm sure you've read, is very narrow. It's about 1 or 2 sentences, and simply states that that the amendment abrogated the right to reimbursement that the court had already recognized up to that point. And I would submit to you that that is simply because the footnote overread what was intended by the amendment, which was to require the workers' compensation carrier to pursue PIP benefits against the liability carrier, and that there would be no reason at all to make that distinction if the workers' compensation carrier were always and only required, or only permitted, I should say, to go against the liability insurer. If there was already that limitation, why single it out with regard to PIP eligible benefits? I'll reserve the rest of my time for rebuttal unless the court has other questions.
Thank you very much, Mr.
Thank you.
Baker.
Good morning, Your Honors.
Good morning.
Your Honors, we're here on an appeal from a decision by the Superior Court granting our motion for judgment on the pleadings. And the pleadings with the declaratory judgment action filed by them, the answer filed by Cincinnati Insurance Company, and the answer filed by Mr. Henry. In the declaratory judgment action, it was alleged that the pre-2016 amendment was used in Henry to say that they now have a right to subrogate. Both of that allegation is denied in both answers. We then filed a motion. The court heard argument, granted the motion. They filed an appeal. The sole issue raised by them on appeal is that the 2016 amendment to 2304 expressly grants employers the ability to pursue a lien against UIM benefits paid to an employer's injured employees. What they ignored then, they seem to have recognized now, is that version was not in effect at the time of Henry's accident. It was not applicable to Henry's accident. It does not have any bearing on this case at all, but all of their arguments in their brief are focused on that argument. That's the only argument that they preserved. That's the only argument they presented.
So how do you get to raise that now?
How do I get to raise that now?
Right. At least I understood what you're just saying is that the accident occurred in 2015 and therefore the 2016 amendment did not apply.
We've always maintained that, Your Honor. And this court found that the 2015 version applies in the Henry decision that allowed Mr. Henry to pursue benefits. If I may, the case itself says that the 2015 amendment applies.
So I'm just trying to make sense, and my head hurts.
I understand.
That there's an argument here that the argument was not, and maybe I'm misidentifying the argument, that the argument was not raised below.
And I'm perplexed by that as well. I do not understand where that comes from, because it was certainly, again, we're dealing with a judgment on the pleadings. They alleged it in the complaint. I can go through the complaint and the answers and cite the paragraphs if Your Honors would like me to do so. They alleged the 2016 amendment applied and gave them subrogation rights. Both of our answers denied that or indicated it's a legal statement which requires no answer.
Mr. Crawford, you referred, as you launched this argument, to their briefs here.
Yes.
And you gave us the caption of their argument, but they did argue, did they not, that the 1993 amendment to 2363E did not address UIM insurance in their brief.
If I may, I believe they raised all of the issues that it doesn't matter which version came for the first time in their reply brief.
Okay, we can read the brief. And didn't the Superior Court deal with the issue as it's been framed today?
The Superior Court dealt with the issue, yes, and the Superior Court, I don't think, gave any substance to any argument that the post-2016 version applied, because it simply didn't, and it's the rule of the Henry case.
But the Superior Court addressed how 2363 operates in relation to the issue before us, correct?
Yes, Your Honor.
All right.
Yes, it did. It's our position that it does not confer any additional rights to them. We believe the Superior Court decision got it correct when they found that in the Henry decision, referring to Cincinnati as standing in the shoes of the third-party tortfeasor, that's in relation to, it's separate from PIP, whereas PIP is a no-fault policy, and all one needs to do is show that they had an accident that involves a PIP-eligible benefit and they're entitled to it, as opposed to UIM, where they must, in fact, show fault. And in those circumstances, the UIM carrier stands in the shoes of the tortfeasor in terms of any defenses or liability. And I believe that's all that was meant by Henry indicating that. And the Superior Court seemed to take the same approach, not just into the decision in this case, but in the prior motion to intervene in the actual Henry 1 case. The court took that same approach, indicating that that's reading way too much into that phrase and what was intended by that phrase.
Wait, Mr. Crawford, if I can just clarify, when you say that phrase, do you mean the statutory reference to 2118?
No, I apologize, Your Honor. The phrase being the phrase in Henry that said that we act as a third party.
So can you tell me, because it's not clear to me from your brief, can you tell me what effect you think the statutory reference to 2118 has on the interpretation of 2363?
As it relates to the UIM?
Correct.
I don't.
And specifically to the issue in this case, which is whether or not an employer can assert a lien against UIM recovery.
I don't know that it has any great specific effect. That wording, I think the more important wording is when they talk about any recovery against the third party for damages. And while Cincinnati is a third party for establishing UIM benefits, they're not a traditional third party. If one were to take that argument, then the statute would allow them to go after somebody's privately purchased UIM benefits. If we're going to read the statute that broadly, there's no limitation that says it doesn't apply to an employee purchase policy.
So are you saying that the reference to 2118 means nothing?
No, I'm not saying it's nothing.
What does it mean?
I'm saying that the reference to 2118 is clearly specific for PIP. And I'm saying that this court has determined that the provisions of 2363 do not allow them to assert the lien that they are asserting.
Mr. Crawford, I want to maybe help you along on this. At page 16 of your brief, you quote, as did Simendinger, and as did the trial court here, that last part of that sentence that says, and you argue that the plain language of section 2363 itself limits an employer's right to reimbursement, and then you quote and underline and put in bold, only from the third-party liability insurer and shall be limited to the maximum amounts, blah, 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 to the end. But the phrase that comes before that is the one we're talking about now that appears to limit that, the applicability of that latter phrase, to PIP benefits. Doesn't the limitation on PIP benefits, that is the part that was not included in the quotation, make the part of 2363 that you quoted irrelevant to the issue before us?
Perhaps, Your Honor, but I do believe that now that I appreciate, thank you. It specifically references 2118, but then it goes on, and I think the important thing for us is reimbursement shall be had only from the third-party liability insurer and shall be limited to the maximum amounts of third party's liability insurance coverage available. We are not the third-party liability insurer. We are an UIM carrier. We are not a third-party liability insurer. So I think they're limited to getting what is available through the third-party liability insurer, and they don't get to jump over and take UIM benefits.
If the statement in Henry 1 that the UIM carrier steps into the shoes of the third-party tortfeasor or carrier, if that was something more than dictum as you have depicted it, do you lose?
I don't believe so, Your Honor, because although it may say that we stand in the shoes of the third party, it doesn't say we stand in the shoes of the third-party insurance carrier. It doesn't, and this limits, the statute limits it to what's available from the third-party insurer.
But that's for PIP benefits, right?
No, Your Honor, I believe that that's extended beyond PIP benefits.
So, again, can you walk through your textual analysis of how you think that is extended beyond PIP benefits?
So I think it addresses both, is the way I interpret it. And if I may, except for the items of expense which are precluded from being introduced into evidence at trial by 2118 of Title 21. So that takes PIP out. It says you, except for the stuff in PIP, you can't get it. Now we go to reimbursement shall be had only from the third-party liability insurer and shall be limited. And I think that's what brings it into being applicable to us today and being applicable to, you don't get to go from the liability insurance carrier and also go to the UIM carrier. Again, to make that leap, they then get to attack Mr. Henry's own personal UIM policy, which they've conceded they don't get to do. There's nothing in the statute, there's nothing in the wording that would separate between UIM carriers. Absolutely nothing. So extending them, one, would rename a UIM carrier into a third-party liability carrier, and two, would extend it to benefits that were purchased by an injured employee on their own, which I don't believe is the appropriate result. And the talk of double payments, if I may, what we're dealing with here is Horizon had two separate insurance policies. And under the Workers' Compensation Act, they have an obligation to pay the benefits they paid. We have issued an uninsured motorist policy, And under that policy, we are obligated to pay the benefits that are mandated by that policy. And that policy specifically limits those benefits. It actually excludes anything that was paid by workers' compensation. So by their very terms, there is nothing for them to attach a lien to because we don't pay any benefits they paid. They're two separate benefits, two separate payments. If Mr. Henry is to recover, all of it is going to be for things that are not paid for by the workers' compensation carrier. And Mr. Henry and his attorney have acknowledged that, and they have conceded that to the court in the Henry case and in argument in this case.
Your friends say that's not before us today, that they're merely attempting to assert a priority lien on whatever Mr. Henry can recover under his UIM policy. Why is that flawed?
It's flawed because if we don't pay any benefits they've paid, there is nothing for them to attach. So in some other case, theoretically, if the UIM policy did not have a non-duplication provision, which most I've read do, theoretically, maybe they could make their arguments. In this case, they don't get to make their argument because they keep saying, we have a right to get anything Mr. Henry gets. We have a right to get anything Mr. Henry gets. Well, they don't, because we don't pay anything that they've already paid. Even if they have a lien, which they don't, they only have a lien on benefits they provided. They don't get a benefit on lien on benefits they haven't provided. They're trying to attack Mr. Henry's entire recovery. And they're saying, oh, we'll work it out later, we'll work it out later. No, because there's nothing to be worked out. We don't owe any benefits that have been paid by them.
Could you help me understand this exclusion, which I understand the part that you're relying on is this insurance does not apply to any of the following, and then I go down to 2, the direct or indirect benefit of any insurer or self-insurer and under any workers' comp law. Is that the provision you're relying on principally?
If I may have a moment, Your Honor.
Page 18 of your brief.
Yeah, I'm sorry.
I was trying to find the actual policy, but I appreciate I'll go right to the brief. Yeah, at the bottom of page 18, the limitation of liability, but it also goes under the exclusions, which begins on page 17.
Yeah, I'm looking at the exclusions. The exclusion C2, and I'm having a hard time, and I realized from reading the other cases, is it apparently appears in UIM policies, but I'm just trying to understand the language. How does that work in service of your argument that exclusion limits their ability to assert a lien here?
That particular exclusion indicates that there is no benefits payable that would be directly or indirectly for the benefit of any insurer, self-insurer, any workers' compensation, disability benefits, or similar law. In other words, to the extent that the workers' compensation law has ordered another carrier to pay benefits, we will not pay. We exclude any benefits that would be to the benefit of that carrier. And I think it has to be fleshed out when you look further down at the limits of insurance, where they go into a little more detail on that. And the specific is, we will not pay for any element of loss if a person is entitled to receive payment for the same element of loss under any workers' compensation, disability benefits, or similar law. And those provisions have been upheld. And in fact, I don't believe that the enforceability of that provision has even been challenged in the Henry case.
Have those provisions been upheld in Delaware?
Yes, Your Honor.
So the argument is that there's nothing to lien.
Correct, Your Honor.
And that's why I'm wondering why we would be deciding this case if there's nothing to lien.
Well, I don't know, Your Honor.
Mr. Crawford, do you concede that Mr. Henry's complaint in the UIM action, not in this action, but in the UIM action, seeks damages or alleges damages that were compensated under the workers' compensation policy?
Yes, Your Honor. And I believe at the time Mr. Henry filed his complaint, he did not have the benefit of having our policy and our policy terms. So the complaint was filed, obviously, to be over-encompassing and to include any and all damages that he possibly could obtain. At UIM, it's essentially contract. You take a look at the policy. They have now conceded, after having the policy and reading the policy, that they are limited to obtaining benefits that were not paid by the comp carrier.
You say they've conceded it. In what context? Is there a stipulation? Is there something on the record in that case that we could look to?
There is. It's on the record, and I believe in the argument in, I believe it was dealt with in this case. It wasn't. It was definitely dealt with in the argument before Judge Roccanelli.
Is that in the record? Have you given us that in this case to look at?
I apologize, Your Honor.
Do we have that in any of the materials you submitted?
I don't know if you do, Your Honor. I know you have the one that was the argument for this case, and I do believe that, if I may have a moment, that it was dealt with. If I may.
You can get us the site after argument.
I recall from the argument from reading this yesterday, and I apologize, I did not mark the page, that Mr. O'Neill did acknowledge that they are not seeking any benefits that have been paid by the comp carrier. But it certainly has been stated in the actual Henry case that is not before you today, but that is the one that they tried to join and that ultimately would give Mr. Henry benefits.
I think for the record, it's A17. It's page 10 of the oral argument in front of the trial court in this case.
Yes, correct. Mr. Henry, Mr. O'Neill, I will confirm that in terms of the underinsured motorist that's pending. Separately from this, it is for pain and suffering, past and future pain and suffering compensation, whatever was paid by workers' comp. We are not seeking that as part of the underinsured motorist action. So I will confirm that, Your Honor. Thank you, Your Honor. Bulk of my argument. If Your Honors have no more questions, I'll return the rest of my time.
Thank you very much. You going to clear it all up for us, Mr. Baker?
Mr. Crawford contended that the lower court did not address the construction of Section 2363, and yet that is exactly how the lower court cast the issue. On page 5 of the lower court's decision, it states as follows: this dispute boils down to whether an employer and their workers' compensation carrier are entitled to a lien on any UIM benefits paid by the employer's UIM insurer under Section 2363E of the Delaware Workers' Compensation Act.
Mr. Baker, how do you respond to Mr. Crawford's argument that nothing in the statute distinguishes UIM carriers, and if you read the statute as broadly as you want, then recovery could be had against an employee's purchased UIM insurance?
Well, not every term is defined by the statute, which is why we have this court's ruling establishing in Adams versus Delmarva that it is limited to the employee's, to the employer's purchase coverage, and that was an important distinction in the court's mind at that time, and I think that there was good reason for it to be a distinction, because the employee has undertaken on its own initiative, on her own initiative, to purchase UIM coverage. Here, the employer undertook to purchase UIM coverage, and if this decision stands, as per the lower court, would be denied any benefit from that policy. All of the policy, all of the benefit would go to the non-purchaser, and none of the benefit would go to the purchaser. And there's simply no reason why that should be the case.
Could you address the last subject your friend focused on based on the court's questions about there's not going to be anything paid out under this UIM policy that was covered by workers' comp?
Well, I can only state what I stated before that. I don't believe that is before you because that is not what the Superior Court addressed. The Superior Court merely addressed the construction of Section 2363 and whether that by law precludes a UIM carrier in all circumstances from any recovery. We submit that it does not. The Superior Court did not get into the weeds with Mr. Crawford over the technicalities of the language and based its decision entirely on the statute and not on the contract.
If your friend's view is correct, would it be possible for UIM claimants and UIM carriers to characterize a UIM recovery in the manner in which they did here for the purpose of avoiding an otherwise valid work comp lien?
I think that's exactly a risk, Justice Traynor, that since Mr. Henry's got nothing to lose by so doing, that he would characterize it in such a way that the workers' compensation carrier would be essentially bound by an agreement to which it was not a party, to which it contributed nothing in terms of the discussions or the negotiations, and then be able to say, but because we agreed to something, that precludes them from any recovery. I don't think that the law should work in such a way that two parties can decide among themselves what the rights of another party might be. In this case, I believe that the Superior Court is correct, that the statute is what governs our rights, and that the Superior Court is incorrect in terms of how it defined that statute, because, as you said, Justice Traynor, the language of the statute is unmistakable, that the only limitation, except that 4 items of expense, which are precluded from being introduced into evidence at trial by 2118, reimbursement shall be had only from the liability insurance carrier. The statute does not parse out whether we can get a recovery from this benefit or that benefit or that benefit against other parties. The only exception it makes is PIP benefits. And so if there's a recovery against the UIM policy, which is treated by this court as a third party, which is treated by this court as standing in the shoes of the tortfeasor, then we should have the right to subrogate against it. And we should not be contracted around by language and agreements in other forums and other proceedings from which we were prevented from participating. As the court may recall, we tried to intervene in that action and were denied that opportunity. So if there are other actions and other agreements that are not part of our, that we are not a party to, then how can we be bound by them?
Is the language in the UIM policy enforceable? It's not illegal, is it?
If it is against public policy, it is certainly not enforceable. I
think you heard your friend say that that language has been upheld before.
Well, then, if we get to that point, then we'll deal with whether we have a right to deal with specific benefits that are paid. But the question before us right now is whether 2323 lets us get that far.
Well, I'm just worried we're taking things out of order here. That we should have figured out whether, and of course this may be our fault, the way we manage things, but it seems like we should have figured out whether there was something to lien first and then fight over whether you were able to make a lien.
Well, the court, I'm not going to tell the court how to decide the case, but I can submit to you that the Superior Court addressed it as a statutory construction, and it is my position that the parties cannot agree on some side deal, that we're only going to accept this as for non-workers' compensation benefits, and thereby shortcut the provisions of that statute.
Might it be a ripeness issue?
Sorry?
Might it be a ripeness issue?
If the court so concludes, but I think that what we need to establish for the moment is, does the statute preclude us from getting to that decision itself? Does the statute prevent us from even making that a relevant inquiry as to whether the contract precludes us in this instance? Because right now, the law is that no UIM carrier can recover against the that no workers' compensation carrier can recover against the UIM carrier.
What happens if a UIM insurer pays out a claim with the work comp carrier not having made or asserted a lien? Is there some...
Then there would be a credit. So if the UIM carrier...
Would there be any restriction on the claimant's ability to use the settlement funds?
Well, that's a good question, Justice Traynor, and I think it may help the court with regard to the ripeness issue, because if Mr. Henry has paid benefits that could be paid in the future, we would likewise be foreclosed from asserting a credit. And why should that be? Because Mr. Henry is going to have additional medical expenses, perhaps additional lost wages, perhaps increased impairments, perhaps a host of other benefits in the future. And as
I think if I understood Justice Traynor's question, it's better to have a lien before the money goes out the door.
That's...
Well, it is, but I think that the flip side of that goes to the question of whether truly these are only non-work comp benefits under the contract, as Mr. I see my time is up. Do you want me to finish the answer? As Mr. Crawford has clarified it, because even if they're not work comp benefits today, they may become work comp benefits in the future when Mr. Henry incurs additional damages.
And that's why you also described it as a credit, so there's no real prejudice, because it can still be a credit against future payments.
Only if this court allows us to subrogate against it.
Understood. Thank you very much, counsel. We appreciate it, and we'll take the matter under advisement.
Please rise.